Good morning and welcome to today's Ask a Pro webinar. I'd like to thank everyone for joining us today. Today's topic is commercial collections and litigation 2022 and beyond. My name is Shawna Chambers and I will be the moderator for today's session. I'm the Director of Commercial Collections and I'm located in our Columbus, Ohio office, which is located in Dublin, Ohio. I've been with the firm for a little over 20 years. And during my time with Weltman, I've served our clients in a variety of management roles. As Director of Commercial Collections, I am responsible for the daily management of the firm's Commercial Collections business unit. Now let's learn a little bit more about our panelists for today. First off, we'll start off with you, Nick Rohner. If you'd like to introduce yourself.
Hi, everybody. My name is Nick Rohner. I'm an attorney here in our firm's Cincinnati office, and I look forward to talking to you today.
Thank you, Nick. Good morning, Andy. Why don't you tell us a little bit more about yourself?
Good morning. My name's Andy Voorhees. I'm an attorney and shareholder for the firm in our Brooklyn Heights office in the Cleveland area. I've been practicing commercial collections for a little over 17 years now, and I'm looking forward to speaking to you all this morning.
Very good. Thank you so much, Andy. David, let's learn a little bit more about you, if you don't mind.
Thanks, Shawna. My name is David Wolfe. I'm a shareholder and attorney here at the firm. I've been with the firm just over 22 years now. I am the managing attorney for our Michigan office, and I handle the Michigan litigation and Florida litigation for commercial collections for the firm.
Thank you very much, David. Before we get started this morning, I would like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button that you'll find in the control panel. Questions will be addressed during the presentation where applicable. This webinar is being recorded, and at the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all attendees. Lastly, there will be a short survey on your screen at the conclusion of the event. So please take the survey and share your feedback because we greatly appreciate hearing your opinions on our webinars. Without further ado, how about we go ahead and let's get to the first question. And the first question is going to be coming to you, Nick. Question of the day: how has the pandemic changed commercial collections and litigation?
All right, Shawna, and everyone, it would be remiss of us not to first talk about this and how the global pandemic has affected things in the legal industry. It's been almost 2 years now, almost exactly 2 years, but 2 years ago, most of us were quarantined. The courts had to make adjustments to how they did business. And so the biggest change in commercial litigation throughout this period has been the use of remote hearings and depositions. I don't know about most of you, but I hadn't heard of Zoom until the spring of 2020. But during that year, almost all of the courts across the nation started utilizing either Zoom, WebEx, Microsoft Teams, or a similar platform in order to conduct their business. And then others also who didn't maybe utilize those platforms did go to telephonic hearings exclusively. And so what I think everybody learned in 2020 was how efficient these remote platforms could be, especially for the attorneys and our clients. Now, while some of the judges struggled to utilize the technology, and which led to some frustrating and sometimes funny moments with these in court, overall, the attorneys, without doubt, and our clients benefited from them. Remote hearings are basically, they're just less time consuming, and not necessarily the hearing itself. Those take about the same, but it's the travel to and from the hearing, which is where the cost savings is. So that means less billable time for the attorneys, which benefits obviously the clients, and just that elimination of the travel to and from the courthouse is where the efficiency is. And that's why we're certainly a big promoter of these hearings. And these also aligned with our clients' interests, because a lot of you had travel restrictions during 2020 and beyond, and because you didn't have to appear or no one had to appear at those hearings in person that aligned with your interests. You could also attend if needed remotely. So the question now is, what's going to happen now the pandemic's winding down 2 years later? Are courts and judges going to allow us to appear remotely? And like a lot of answers, the answer is it depends, and it depends on the jurisdiction and sometimes the specific judge. So what some courts are doing, for instance, I'm licensed in 3 states, Indiana, Kentucky, and Ohio. Well, in Indiana, there are some courts that have been doing Zoom hearings ever since the spring of 2020, and they've given indication they're not going to stop. Like, they are going to, at least for the foreseeable future, regardless of the of the pandemic situation, they are just going to keep doing remote hearings in their courtroom. There are some courts, especially in Kentucky, where judges have taken the position that we're in person now, and we're never, we're not going to do anything else other than if there's more, orders from the the health authorities. So they've gone strictly in person. There are some other courts where they're doing a hybrid, which is they're allowing people to appear in their courtroom, but they are also allowing people to appear by Zoom if they choose. I was in a Zoom hearing this morning where a judge made the announcement to everybody on the Zoom call, the attorneys, and to the people in the courtroom, that permanently they are going to allow Zoom appearances in that courtroom because that's what the attorneys wanted. Attorneys requested that. Certainly our firm's been a big advocate of it. And so he had decided that they're just going to keep it. And so that's really great news that there are judges doing that. And again, you will need to check with the individual court and jurisdiction, but there are courts that have made that permanent change, which is really going to provide some great efficiency for everybody involved. But the bottom line is that even though we're advocating for the continuance of these Zoom hearings, there are going to be plenty of courts out there, especially probably over the next 6 months or so, as things are winding down with the pandemic, that they're going to make the decision to go back permanently in person. And so as our clients, if you have travel restrictions in place right now, you may need to consider relaxing those so that you can provide witnesses at trials and other hearings where they're needed. So that's just the kind of reality of the situation that we're in. The other thing that's really permanent change that's come out of the pandemic has been e-filing and the acceleration of that. Now, some courts, obviously the federal courts, have been doing e-filing for a long time, and some states, for example, Indiana, they completed their e-filing installation, I believe, in 2018 across the state. So they were already prepared essentially for the pandemic when it happened. But for the ones that weren't, they were partially had it partially in place, or maybe they were thinking about doing it. The pandemic was sort of a wake-up call and provide them motivation to get that project done. We have, for example, we have a Detroit office, and Michigan is a state that currently has just a few circuit, like David's in that office and he'll be speaking later, but just from my understanding, a few circuit courts have it and one district court has e-filing. And now there's talk about doing it statewide. During the pandemic, the courts would, especially the initial quarantine, I should say, the courts could only accept filings by mail. There were no in-person filings. And so when everything's coming in by mail, there were certainly delays because a lot of those courts didn't have their full staff. And apparently, according to someone else that I talked to in that office, there are some courts in Michigan that are still catching up from those delays that resulted from the pandemic and not having the ability to e-file. So for you, our clients, e-filing is overall a very positive step forward. While there are some convenience fees that have to be paid normally at the beginning of a case, so for instance, in Indiana, there's a $6 convenience fee that's paid right up front, which is a cost. But over the life of the case, there's money saved on other things like postage, paper. It is, again, more efficient and faster. So e-filing is the present, and it's in the future across all courts in the country.
So I'd just like to chime in a little bit on our status in Michigan and Florida with the remote hearings. Florida, the judges that I've had a chance to speak to about the issue, they like, in general, they like the remote appearances. I think it keeps the group of people out of their courtroom and allows them to move through their docket much more efficiently. To Nick's point, so we think it's going to continue, at least for more run-of-the-mill type hearings, pretrials, status conferences. We are seeing in Florida that contested hearings, the courts are starting to require that we come back in person for maybe summary judgment motions or trials where they require witnesses. So that, I think that trend will continue. We have been successful in the last few trials that I've had, that we've been able to appear by Zoom on the theory that these are not heavily contested facts. So a lot of times we're bringing a custodian of the records as our witness, and that person's simply going to testify to the documents and to the outstanding balance. There isn't a credibility issue where judge wants to look the witness in the eye and make sure that they are, and judge their credibility. For the custodian of the records, the reason we can use a custodian of the records are because the documents are trustworthy in and of themselves. So I think that will continue, and we'll continue to push for remote appearances to the extent that we can, so that we're not requiring the appearance of our witnesses down in Florida and to travel to Michigan or Florida. So
Thank you both, Nick and David, for that. Kind of along the lines in the same vein, remote online notarization. Nick, can you speak to that? How does that exactly work?
Yeah, sure, Shawna. So this is definitely a product of the pandemic. A handful of states had actually installed remote online notarization.
I think we might
Nick
have
Rose,
lost Nick.
Prior to the pandemic, just by coincidence. Like, for instance, Ohio did it in 2019, right before process in the spring legislation. Iran has been adopted in a majority of states now. I think it's pushing 40 now by last count. You have to check your respective state for the licensing requirements and to make sure they have it. It is different than a regular notary. Normally, for instance, in Ohio, you have to be a notary already, and then you take a course, like a 2-hour course, and then you have to pass another test. So that's sort of how that works in most states. And so what Ron really is, it's a system where the signer appears before the notary through visual technology, and that's over the internet, instead of being physically in the room with the notary. Now that's different from electronic notarization. Electronic notarization basically allows a traditional notary to obtain an electronic seal, an electronic signature that they can use to notarize documents on the computer while they're sitting in the same room with the signer. So in those and I think that is becoming more and more prevalent, where the two, they'll be in the same room with the signer, and everyone's signing on the computer basically electronically. And so that's electronic notarization. But Ron sort of takes it a step further. It allows the notary to notarize it without being in the same room. And of course, the purpose of the notary is not to verify the contents of the document, but rather to verify the identity of the person signing the document. So the big question is, so how do you verify someone's identity when they're not sitting in the same room with you, when they're communicating with you through a computer screen, basically? So you can see them, but you can't physically review their driver's license. So how does that work? And well, it depends on the state law, of your state. There's some states that make it as simple as you hold up your driver's license to the screen, and the notary just looks at it to confirm, and looks at you to confirm that is the person that's signing the document. But the majority of states make it a little more difficult. They use something called knowledge-based authentication, which is run through a computer program, and it's similar to if you request your credit report through the federal website. It'll ask you, before it issues you the credit report, asks you some questions about you, like, pick an address out of this list that you've lived at in the past 10 years, or do you know this do you know this person, or which person in this list is considered an acquaintance of yours. So it digs into your sort of personal information to make sure you can answer some questions correctly, to make sure you're the actual person that's going to be signing these documents. So that's more common, but they're all built into these programs, this software, this remote online notary software. There's several different companies that make it, but once you become licensed, you have to contract with one of those companies to provide the software so that you can do online remote notarization. So one question that comes up is, does the online notary have to be located in the same state as the signer? So they're still viewing each other through a computer screen, but do they have to be in the same state when that happens? And the answer to that question, once again, depends on the state. For instance, Arkansas requires the signer and the notary to be located in the same state. So they can be 150 miles apart, but they both have to be located in Arkansas. A lot of states don't have such a requirement. So you could have a signer located in Tennessee and the notary is actually in Virginia, and that's completely fine. And if you want to see how the process works, if you go to Google or YouTube, there actually are some videos out there really going through how an online remote online notarization works, and it's pretty interesting.
Thank you so much. That was very interesting information. Moving along to the next question. David, this one is coming your direction. And what documentation is required for a successful lawsuit?
Thank you, Shawna. It depends on the nature of the claim and the jurisdiction, but fundamentally what a creditor needs to provide is the documentation necessary to establish liability. In most cases, that's a promissory note, and if there's multiple debtors, you might have a guarantor. So we're looking for something where the defendant has made a promise to repay the debt. Now that could be in situations where maybe you're dealing with failure to pay invoices. The debtor may have signed a credit agreement and then had run up invoices that just didn't get paid. So we would want to see, in that situation, we'd want to see the credit agreement that the defendant signed, as well as the copies of the unpaid invoices, so that we can establish that they had an obligation to repay, and then the invoices show the debt that was not paid. So again, it depends on the nature of the debt, and then as well.
Thank you for that. The next question kind of ties into that. So do you use the same documents for every lawsuit, or?
No, again, if you're suing on a bank loan, for example, there may have been a promissory note or a business loan agreement that might be necessary to establish the liability of the primary obligor versus and then if there's a guarantor, that guarantee establishes the guarantor's liability. Again, you might have unpaid invoices that requires a different type of documentation. And you might have and I do some title recoupment work where the debtor's liability is based on a warranty deed that the debtor signed, transferring real property to the other party. That's the contract. The warranty deed in that situation is the contract. Maybe there was a closing affidavit signed at the same time. That closing affidavit may establish additional liability. So again, what we do when we get a file in the door is we're looking at what is the basis for the claim, what type of debt is this? Is it a simple bank loan, or maybe a car, a vehicle finance? So you would be looking for the vehicle finance agreement and any guarantees that go along with that. Maybe a commercial security agreement that gives the creditor rights in the collateral if they have not yet repossessed the collateral. So it depends on the nature of the claim in general, and then the jurisdiction as well.
Okay. So moving along to, state jurisdiction. So how does that vary? Does every jurisdiction require the same documents?
No, in Michigan, we are more of a notice pleading state, so we can, our pleadings can be more basic, that the defendant entered into an agreement, they failed to make payments as agreed, and they owe the client money, or the elements. But in Florida, for example, that jurisdiction is what they call a fact pleading state, where we must plead the ultimate facts necessary to establish our claim. So we're going to look for additional documentation. As an example, I do some equipment finance work for creditors, and I'll allege the breach of the contract, or I'm sorry, the existence of the contract and the guarantee, but also that my client, if they've repossessed the collateral, that it's been repossessed and sold in a commercially reasonable manner. And I would then also attach the notice of disposition of sale, and then the calculation of deficiency balance as exhibits to the complaint as well. So in that situation, the documents vary a bit because of the way the courts require us to plead our claims, both in Michigan and Florida.
Okay. Thank you for that. Appreciate it. As you move in, to the litigation process, are there additional documents that our clients, are required to provide during that litigation process?
Absolutely. Oftentimes we'll have defenses that are raised, possibly for a signature defense that was not my signature. Well, what we may need additional documentation to establish that the debtor actually signed the documents, or if the defense is that the sale was not held in a commercially reasonable manner, we might need more documentation to establish that the sale was conducted, that the sale of the collateral was conducted in a reasonable manner. Also, in both jurisdictions that I practice in, we need a client affidavit that establishes that there was a breach and that the damages were suffered by the client in a given amount. So most times we're asking for additional documentation from the client, but we're very specific in our requests.
Okay. Thank you very much. Andy, this next question is for you. So how do I proceed if I'm not the original owner of the account?
Thanks, Shawna. This situation kind of continues on what David has just been talking about what is needed to bring your claim and prove your claim in court if you're not the original owner of the account, if you're not the original credit grantor, if you're not the original supplier of goods. How do you proceed? And this can arise in a number of ways. You may be a bank or other financial institution that merged with another entity, another financial institution, and therefore all the accounts that the old bank had now becomes your property and your claims. You could be an organization that regularly purchases debt, and you buy debt in bulk, and you'll have hundreds, sometimes thousands of accounts that you've purchased that now become yours. Or a situation might be a one-off. You might purchase one account from another entity. You may have taken over another business where their accounts receivables become your accounts receivable. So in this situation, there's an extra layer of proof that you need to provide to the court to advance your claim, to show that you as the party in interest have standing to proceed. So what are those additional documents that you may have? Well, if you're an organization that regularly purchases debt, it's important to have, first off, a bill of sale. The bill of sale serves as evidence that there's a transaction between the two parties where there are accounts being sold and subsumed by the new creditor. So the bill of sale is kind of a receipt in a way. kind of an agreement as to what has been sold. So how do you prove that you are the actual owner of a particular account in a lawsuit? Well, it's important to have more detailed information as part of that bill of sale. Now, if you're selling one account or you're purchasing one account from another entity, it's easy to list that account in the bill of sale itself. However, if you're purchasing thousands of accounts, it's important to have documentation of the exact accounts that you are purchasing, and that can typically be added as an exhibit to the bill of sale, showing a listing of the accounts, identifiable by account number, an individual's name, the amount of the debt, and the date of the debt itself. So many courts will require you to have that information to show that you have standing as the proper party in interest to proceed. A bill of sale, an identification of the account at issue that you actually purchased as part of that sale. And if you're a bank and you've merged with a smaller bank has merged with your organization, or a smaller credit union has merged with your organization, and there wasn't a bill of sale per se, how do you show that the accounts of the old financial institution are now your accounts? In that type of situation, you typically need some sort of certification from the comptroller of the currency in Washington, D.C. And this is typically it's something in letter format showing certification that your institution has merged with this smaller institution. And that's typically good evidence for the court that you are the proper party in interest. Now, if you're just a business that is not really regularly purchasing debt, but for example, you're a food goods supplier and you want to purchase another food goods supplier, and you want to purchase their assets. How do you prove that the accounts receivable from the old food goods supplier are now your accounts receivable? In that type of situation, it's important to list in the purchase agreement for purchase of the assets of the business that you are clearly stating that you are purchasing all the accounts receivable of the old business, so that you are free to proceed as the proper party in interest. So to sum up everything regarding documentation, you need an extra level of proof beyond what David talked about. Not only do you need the note or the statement of account or running balance, but if you are not the original creditor, you also need a bill of sale that identifies the account that you are attempting to collect upon, or some other merger document or agreement showing that you are entitled to collect on that accounts receivable. Typically, if you get into a lawsuit and you don't supply that information off the bat, your opponent may file a motion for more definite statement or some other contemporaneous motion asking you to provide that information to show that you do have the right to proceed.
Thank you very much. I'd just like to remind the audience, if you have any questions throughout the webinar, please don't forget to submit those in the chat window, and we will work them in as we proceed forward. Andy, this next question also comes to you. So how can I testify in a deposition or trial if my organization did not originate the debt?
Okay, so this is the next step after the original pleading stage. So you've gotten this far. You've supplied sufficient documentation to the court showing that that you at least are arguably the owner of the debt by virtue of the bill of sale or other accompanying documentation showing that you are the proper party in interest and have standing. So as you get further into the litigation process, you may be called upon to be deposed or testify at trial as to the records of this prior organization. of which you've purchased the debt. So just like in the pleading stage here, you can testify as to these documents by, adding an extra layer to your testimony as to the documents that you're seeking to authenticate as records custodian. So, for example, when you're asked to testify as to the authenticity of documents that were not created by your organization, but became part of your organization as part of a purchase or transfer of accounts, you must be able to testify that the records of the prior organization were acquired as part of this purchase and merger, and that you were relying on the accuracy of the records of the prior organization, and that you're keeping these business records in the ordinary course of business. If you are the records custodian and you can competently testify to this, that will usually be good enough for the court to allow you to testify as to the accuracy of the documents themselves, as to the balance due, as to the terms of the agreement. So in this situation, it requires an extra level of questioning from your attorney to get over that hump.
Okay, thank you for that, Andy. We received a question, and David, I'm going to give this one to you. How long can you attempt to collect on a charged off loan?
A charge off, and that raises a couple of issues in my mind. I often get a defense, I often get from a defendant that they want to raise the issue of charge off as a defense to paying the debt. Charge off, and I think everybody probably already knows this, but charge off is really an accounting term required by the government to inform the government that the loan is no longer a performing loan and is moved into charge off status, and that's the measure of the financial institution's health. It does not mean that the loan is written off, and the defendants will often try and confuse the court into believing that there's no ability for the creditor to collect on a charged off debt. And my argument has always been, I don't think I've ever had this defense work for a defendant, but my argument is that this is a ministerial act that the financial institution is required to do pursuant to law, and it has no effect on the outstanding debt. I think there's an IRS letter that's on the, I have it in my system and I use it often, that basically says the IRS does not consider that the debt is somehow written off just because the loan's been moved into a charge-off status. And my argument is that the IRS wrote the rule, so they're the best position to interpret that rule. And in every case that I've had where that's been raised, the courts either understand it already, or we explain it to them and they understand that doesn't give the debtor a defense to the outstanding debt, to payment of the outstanding debt.
Shawna, if I could add a little wrinkle to what David was saying, even in a situation where your debt is not only charged off, but you've taken that step to file a tax form 1099-C with the government for cancellation of debt, not even that means that it's the end of your rights to collect upon that debt. There are court decisions that I've researched that 1099-C does not cut off your rights to collect on the debt and receive payment for that debt. You can still refer those claims for collection and recover money on those debts. The important thing that you have to remember, if you do collect on a debt that is subject to a 1099-C, that you have to file an amended form showing that you did recover that debt or partially recovered on that debt to properly document that with the IRS. But that's important to remember too. A 1099-C doesn't mean the end either.
And to circle back and make sure that I actually answered the question, right? How long do you have to collect the debt was the other issue, and the important question. So it's based on the statute of limitations. So in Michigan, we have a a 6-year statute for a breach of contract. We have a 4-year statute under the Uniform Commercial Code to collect on an unpaid sale of goods. So if the financing is for purchase of a car, an RV, a boat, it would be 4 years from the breach, the last payment. And in Florida, that statute is 5 years static across the board. So we measure it from the date of last payment. Truly, the breach ought to be probably 30 days after that. But so it's either in Michigan, it's a 4 or 6 year statute. In Florida, it's a static 5-year statute.
Very good. Thank you. We have a question that has come in from one of our attendees. Andy, I'm going to direct this to you. If I have an account I am not sure that I have the ample documentation for, can I reach out to anyone direct to review?
I'm not sure I understand. Reach out to, if you're not sure if you have the documentation, can you reach out to an attorney to review? Or
I think that's, yes.
I mean, if that's the question, yes. I mean, if you are unsure as to the viability of your claim, it's definitely important to get the opinion of a legal professional. And even if you don't ask, your attorney, before they file any lawsuit binding you to litigation, they should be reviewing that themselves. So, for example, if I get documentation from a client where the agreement itself is not signed by anyone, it lacks a signature, that's a problem that I would bring up to my client about proceeding. If you have a claim where it's quite obvious that the statute of limitations has run on your claim, that's another conversation that we need to have. So not only should you reach out to gain that assurance that you can proceed, but your attorney should also be reviewing that before they affix their signature to a lawsuit and file it with the court.
Thank you. Nick, I have another question for you from the audience. In the case of consumer debt collection, what types of statements or actions by the debtor constitute an acknowledgement of debt that would revive the statute of limitations?
Okay. I think I understand the question. You said, could you repeat it one more time? You said in a consumer setting?
Yes. In the case of a consumer debt, case of consumer debt collection, what types of statements or actions by the debtor constitute an acknowledgement of debt that would revive the statute of limitations?
That's a good question. I mean, I think the most clear one and it is going to depend on state law, but it would be a payment. Paying something after the statute of limitations can reset the clock. And so again, you want to check on, your state. The usually this comes out of the case law in a specific state will address that scenario. But that's the most clear-cut way that a statute of limitations can be revived. Otherwise, it would have to be a pretty definitive writing, I think, for the debtor to essentially waive that defense. It would have to be and I can't say I've ever seen one quite like that where they, essentially waive their rights by simply putting it in, writing us a letter or something like that. And I don't know, David and Andy, if you've seen that before. I'd be curious if you have, what exactly the content of that letter was. But I think normally a payment would be the most clear-cut way to revive the statute.
So just to touch on Florida and Michigan as state-specific ways to revive the debt. Florida statutes say that a payment revives the statute of limitations. It's very clear in the statute. Now, Michigan says that a payment unaccompanied by some sort of denial of further liability, so it would suffice. So, for example, if the defendant just mails in a payment that would start the clock to run again. But if the defendant sent in a payment and said, look, I'm not paying anything else on this debt, then that might not revive the statute of limitations. So I've never seen a writing that Nick is referencing. I know it's probably out there, it's probably available, but I think that any such writing would have to be post default. It could not be like put into the contract. I think that would be unenforceable as a matter of public policy to have a provision in the contract that said you're waiving your right to a statute of limitations defense. But I've never seen a letter that would suffice. But I think it would have to be very clear, and in a consumer setting, I think I'd be very careful about that.
Thank you both very much. Nick, I'm going to give you this next question, kind of in the same vein, so to speak. Is it possible to be sued for FTCPA requirements on the commercial side? And if so, what do you see as the main reasons for that?
Sure, it's possible. Unfortunately, we can't stop, especially pro se defendants from filing lawsuits against us or our clients. So it is possible, but there's a very strong defense, and if it's a commercial debt, simply the FTCPA does not apply, and we would be able to probably dispose of that case relatively quickly through, not a motion to dismiss and a motion for summary judgment. I can't see many consumer attorneys, and that's who we see file FTCPA claims. Most of them, although they're our adversaries, are smart enough to know that, I'm not going to prevail in this case if the debt is not for a consumer, household use. But certainly it's not to say that we couldn't see, you could still be sued potentially, and more likely to be by somebody pro se. It could be for a variety of things. I mean, not sending them initial disclosures, phone call after a certain time of day. I mean, there's a lot of different things, or anything they feel is misleading in the collection of the debt. There's a lot of things inside the FTCPA that they could potentially establish a claim under, but it's the validity of the claim that's important. And I think, in defending a claim like that, we would be able to, I think, resolve it and knock it out pretty quickly if the debt is actually a commercial debt.
I would point out that I was made aware of a new bill floated in Congress by Al Lawson, who's a Democrat out of Florida, U.S. House of Representatives, and he has floated the Small Business Fair Debt Collection Practices Act, and his theory is that small business owners don't have the same protections as consumers. They typically apply for credit using their personal credit, and they don't have those same protections. So they're looking to expand, well, at least Representative Lawson is looking to expand the protections into small businesses too. And I think they're defining small businesses anything under $5 million, the debt being under $5 million. So that certainly encompasses quite a few. So we'll be keeping an eye on that, on the status of that legislation, and keep everybody updated on that.
Thank you. Very timely information for sure. David, can you kind of walk through what happens for a client when they refer a file to Weltman?
Sure. So our clients will refer files to us for us to collect the debt. That's really what it's being referred to us as. So we work with our clients to establish the preferred timeline for that to happen. Often we'll have a pre-suit collections period where the file will be referred to the firm. We'll open it on our system, get the balance all situated, and then it goes into our pre-suit collections program. Andy runs part of that in our Cleveland office, and that the file will be, for a period of time, attempts will be made to contact the defendant and the liable parties and get them onto either a settlement or a payment arrangement. If that doesn't happen in that prescribed period of time, then we'll move the file into litigation, and oftentimes Andy will refer the Michigan and Florida files to me after his team has had a chance to work on it. Sometimes we get some payments. So I saw one the other day that was referred to me where the defendant had been making payments to Andy's group for a while and then stopped making payments, and then it came to me to file suit. So that brings up the issue of when does the statute of limitations start to run, and I say it runs from the last time they made a payment to our office, because that revives the statute and starts the clock running again. So and then we're looking during that period of time, our team, or Andy's team and Jim's team down in Columbus, are looking to determine if making sure that the statute of limitations hasn't expired, that the defendant may or may not have assets to collect. Are they still a viable defendant? Is the business still a viable business? So oftentimes in a commercial setting, we'll have the small business and then a individual personal guarantor. And we're looking to see what's their financial condition at the same time to determine whether the collection is viable. And balance will come into it, statute of limitations will come into it. So all of those factors are looked at before we file suit. And I think Andy touched on quite a bit of that.
Okay. Thank you. Andy, have a question for you. This is provided by one of our audience members. What documents can you request prior to suit when considering a request for payment extension or restructure?
Well, I mean, the short answer to that is, whatever you need to make that decision on your end. There's really no specific limit on what you can ask them to provide in making such a decision. It should be reasonably related to your decision to restructure the loan or extend payments out. I can tell you that a lot of our clients, what they typically use is a personal financial statement form. And many times our clients will have their customer fill out the form on their behalf and on behalf of any guarantors that are subject to the loan, note, or debt, and provide information about their cash position, any property that they own, their income, balance sheets. A lot of our clients require last couple of years tax returns to review in conjunction with such a request. Some of our clients, if there's collateral securing your note, would want to go out and take a look at the collateral and see the condition of whatever the equipment or other collateral there is that is tied up with the debt. So you could ask for bank statements. There's really no end to the financial information that you can ask for, as long as it should be reasonably related to the debt and should be against individuals that are liable on the debt.
Thank you very much, Andy. We have another audience question, and that is, does the firm handle collateral recovery as well as deficiency balance collections? David, would you like to take that one?
Yes, we do that. Part of my before I moved to the commercial side, I did spend a lot of time in Michigan on collateral recovery on the consumer side. So boats, RVs, cars. So we have a very robust collateral recovery program within the firm. We also have a forwarding network that handles those replevin matters in the areas where we don't directly represent our clients.
Thank you so much. Appreciate that. Another question from our audience. Do you see your clients being more willing to restructure the loan and default now more so than before the pandemic? Andy, would you like to take that?
What I've observed is that during the pandemic, the last couple years, I've noticed that our clients are not only willing to be more generous in restructuring loans, but are more generous. We're more generous in accepting settlements or extended payment plans once they've been referred to our office. You know, and that was a function of the situation that we were all in the past couple of years. I'm not sure if that's going to continue now that the pandemic seems to be easing up a bit. I'm not sure how much we're going to get back to normal in that respect, but you know, the past 2 years I've noticed more of a willingness to work with commercial clients based on the market conditions that everyone's gone through. Now that business is ramping up, that you know, we might be get back to some sort of normalcy, that you know, commercial enterprises and businesses are ramping up to full capacity. That may not be the case if they have more of an ability to pay. But I definitely say over the last 2 years, our clients have been a little more generous in restructuring payment arrangement.
Excellent. David, Nick, any additional comments to that from your perspectives as well?
Yeah, I agree with what Andy said. I think there's definitely been a willingness during this time period on the consumer and commercial side to work with people. I think you know, judges too, when some of these cases come up, I think they've implied that they expect, you know, the parties to have worked together, especially during this period. Now that we're getting out of that period, I think that tone might change. But I did actually, Shawna, want to add something to the response I gave earlier to the question about being sued on FTCPA, under FTCPA for commercial debt. One thing I would just advise everyone, all our clients, to do is make sure your loan agreements make it clear that that the loan in fact is commercial. Most institutions are good with that, and it says it right on there, but I've seen some paper whereby it's not clear, you know, and we actually have to dig into the, you know, the file to figure out the purpose of the loan. And so just make sure that your loan documents, you know, if it's commercial, because it's not only important for on the initial, you know, underwriting side of it, but also potentially on the back end too. You know, if we did ever have to collect the loan or collect on the balance, that knowing whether it's truly commercial or consumer is important. So that's just another thing to keep in mind.
And if it's, and it's been my experience, if the courts, if it's unambiguous, I'm sorry, if it's ambiguous as to whether it's commercial or consumer, the courts are going to determine it's consumer. So,
Right.
So
yep.
To your point about making it clear.
Interesting. All good information. Thank you for sharing that. Appreciate that. Next question, David, this is for you. Why are some payments made by the trustee and some directly by the debtor in a bankruptcy?
Well, it usually, so a debtor likes to make their payments directly to the creditor because the trustee takes a fee off of the payments that are made through the bankruptcy. So that's how the trustee makes his money, and that's why he's in the business of being a trustee, is so that he can administer the payments. So for example, we'll see a Chapter 13 plan. This is where it often comes into play. A Chapter 13 plan that'll say, well, we're going to make our mortgage payments directly to the creditor, and then other payments made through the bankruptcy. That saves the debtor from having to pay those trustee fees over time. And it can add up. So as long as the debtor's not in default, it's been my experience that the trustees here in Michigan will allow that to happen.
Excellent. Thank you. Question from the audience. Does your firm have any experience on SBA PPP loans? And if so, what specific requirements does SBA have for collecting on the PPP loans before the creditor submits it to SBA for payment? Andy, or would you like to take that one?
The PPP loans, the collection of which is a new development that's you know, happened in the past couple of years. This is an evolving area of law, and as to the specific items that are needed to collect on such a loan, you know, I would have to go and look and see what it is that we can do to collect on that. I know that there are other areas of our firm that are ramping up collection of such loans for some of our clients. So I would have to get more information on that and circle back on if anything special is needed to collect on such a loan. I'm not sure if David or Nick have any more information on that.
We've done SBA collections for a long time within the firm, and there are those guidelines, and I think that they're still in play with the PPP loans. But what we've seen is most of them have been forgiven. Where I think you're going to see collection is that there's been fraud. So if there's fraud and it's not forgiven, then it becomes like a regular SBA requirements to collect the debt. So I would look at what you're doing for the other SBA collections, and I think we've seen that I think that the PPP lending program has a lot of fraud built into there's been a lot of fraud has occurred in that program. We've seen it on the news where they've jailed some people for their abuses of the program, and but I think we're going to see that evolve, as to Andy's point, that this area of law is going to continue to evolve, but most of them have been forgiven, so we haven't seen a lot on the PPP side for SBA come through, but we have done a lot prior to that program. So
Yeah, I've not had one cross my desk either at this point.
Okay. I believe that's all the questions that we have from the audience. Thank you to everyone who submitted questions, and we are coming up on the hour. So I would like to thank everyone for attending today's Weltman webinar. We hope that you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. So please share your feedback with us and let us know what future topics you would like to see in webinars going forward. I would also like to share that we have a complimentary library of over 25 webinars that you and your team can view on demand. Our collection offers information on a variety of topics, such as collateral recovery, real estate, and bankruptcy, just to name a few. We'll send you a link to the library in our follow-up email, and I'd like to thank everyone once again for attending, and I hope you have a wonderful, great rest of your day. Thank you.
Thanks, everybody.
Thank you.
Thank you.